do Comitê Regulatório do Movimento Brasil, País Digital.
Framework Committee of ABES and also coordinator of the Digital Brazil movement. He's one of the founders of this movement, Brazil, a digital country and movement. So Andre, the floor is yours. Thank you, Rodolfo. So this is a special day in a special week. We are very, very excited about the protection of private data. It's an important day, a special day, because it's really wonderful to start this webinar, which is an international webinar, when we count on experts. Viviane can translate these two worlds because she works in Europe and in Brazil. And we also have simultaneous translation this afternoon. So we hope this is the first of many interesting experiences. We are about to inaugurate, to disseminate this this knowledge transfer promoted by ABES. It's also a special week because in Brazil, we've been discussing this week the enforcement of LGPD. The law should be enforced this week. We don't know if this is going to be so. The Congress, the Brazilian Congress, is discussing this law and the enforcement of this law. And as Rodrigo said, in this scenario where you have a strong coalition from business owners, they are proposing the creation of the framework to guarantee this law to bring more legal safety. The authority that will preside over our Brazilian data protection law, as well as all the legal frameworks, so we can have security in this area. It's a special day because we have much to learn regarding this law. And the question is it possible to advance even without having a regulated law? And we will discuss what we can learn from GDPR, from the Europe legislation, which was passed in 2016 and is in force since 2018, and what Brazilians can learn from the European experience. On the other hand, foreigners who want to work in Brazil, who want to make business with Brazil, they need to understand the Brazilian scenario, the Brazilian situation. So this is the discussion all about. And now, without going further, we have Viviane Nóbrega Maldonado, data protection expert, Justice of Law of the São Paulo Justice Court, and she knows both legislations because she works in both countries. We have Poonam Tiwari with us. She's the head of legal at UK, Europe, in South Africa, and she's also a DPO, Data Protection Officer, which is also in our law. I mean, this figure of the DPO. So she's a data protection officer and Excel service, and she works mostly in the area of services. Daniel Rose, he also works at EXL service as the director of data analytics. So he will talk more about these aspects to us. Poonam and Daniel, they are based in London. So especially in the case of Poonam, she covers not only Europe, but also other regions. And Leonardo Martinez, founder and CTO of Pontus Vision. This is an Anglo-Brazilian company which provides open source tools for data protection. So now let me call our partner Viviane. Viviane, please welcome. The floor is yours. Please talk to us about this rich experience of someone who knows our Brazilian situation and also knows the regulation framework in Europe. Good afternoon. Good afternoon, Andrea. First of all, let me thank you for this invitation made on behalf of ABES, the person on behalf of ABES, Rodolfo and Andrea invited to be here. And Web Summit will be remote this year, but I met you there last year. So if you don't remember, let me tell you that in 2017, I was already studying privacy. I mean, longer than that. Since 2001, I had been following GDPR since its draft, since the directive. And in the second half of 2017, I have said to myself, wait, GDPR will be enforced and Brazil has never heard about GDPR. And I thought to myself, maybe it would be interesting to start to approach the GDPR and understand this law, this regulation regarding also extraterritoriality. We have strong connections between Brazil and Europe in Europe. So we decided to organize the first event on GDPR in Brazil, which was held at the Portuguese board with 3 entities that participated, and ABES was one of these 3 entities. So ABES has this special place in history and in my heart because you made it possible to hold that event. It was a free event and we didn't know back then how well it would be received or welcomed. The idea was to hold this event in, under the perspective of putting together Portuguese company owners and Brazilian company owners to, so they could expand their business in both countries. It was very interesting because back then we realized people started to wonder about this law. It's very, I'm very happy to know how ABES has developed in this area. And Andrie's work was very special regarding digital development features and issues. You are part of history in Brazil because of your work. As you all know, our Brazil's data protection law had been discussed for years, and formally the law was passed in 2016. I mean, the GDPR, but only in May 25th, 2018, it, it was considered in force. So this phenomenon of getting to know or wanting to know more about this law happened not only in Brazil, because the requirement that data that received data from international exchange, they needed to have proper safety and compliance standards according to data protection systems. So Brazil and other countries thought that they would need their own legislation, and they started to consider law drafts, and in a record time, in 3 months. It's not that they were created in May, but they started debating about that, and in less than 3 months, we passed our law, and the draft that became our data protection law was the draft that was very similar to GDPR, the General Data Protection Regulation in Europe. So on one hand, it was a pretty scary time, but at the same time, it made us feel more at peace because we understood the rationale of interpretation, because LGPD always related to the 9543 ordinance, and also based on Article 29 task force, which started back in the 90s. Under this perspective, oftentimes people ask me, are the two laws the same? Are they equal? No, obviously they are not, and I'm going to touch upon some of the differences. Once the directive here in Europe didn't meet the needs of with the increase of international transfers and cross-border transfers in this European Union area, they realized that they should have one regulation. A regulation is similar to an ordinary law. Under this perspective, the legislator tried to incorporate all the contents, and GDPR is huge, 173 sections and 93 articles. So the idea was to design, to choose on that doc word, making some changes. And the first change was to reduce the aspect of the specification of a series of details. And the methodology that was used was to so the authority could choose the details. Let me give you a couple of examples. In GDPR, we have three clear hypotheses of that GPO is mandatory. In Brazil, we say that all controllers need to appoint one DPO. The case of DPIA, the same. At GDPR, we have three hypotheses. Here, we have one article that is not so clear regarding in which circumstances controllers should present reports. They only say that the authority can request such reports, but it doesn't make it clear under which circumstances. So it's hard for us, considering in our Brazilian reality, because as we do not have an authority and we've had vicissitudes regarding the structuration of this authority, we would depend on the approach of this authority that is still that is non-existent right now, to specify some points, some items of this legislation. But this is my personal opinion that most of our LGPD can be observed and implemented right away. Because of the pandemic, as you all know, there was a change so that in August 2021, sanctions will be implemented only a year from now. Oh, I won't worry about that now because it will take a year, but this is a mistake regarding non-compliance consequences. It's precisely right now, I would like to say to you what Europe has to teach us based on GDPR. I don't know if my colleagues agree with me. Companies were always concerned with fines and due to breaches, to leaks, more technical aspects related to accidents, let's say. And we realized that here, if you want to know more about that, you should visit Enforcement Tracker website. You have the list of all the fines that took place from March to now, and all the authorities involved, under which GDPR, which GDPR covers. It used to be 28, now with Brexit 29, or some other countries that compose the EEA. So there is a list there of sanctions that has to do with the aspect that it's evident that there were in fines and sanctions regarding incidents, but most of them are related to other issues because the simple non-compliance with the legislation is capable of generating problems to the companies. For example, especially in Brazil, we have the data owners issue because when our law is in force, maybe in December or next May, proposed by 959 directive, but when is in force, data owners, they have as ready normative framework, and they will not depend on the authority work. If the authority could fine, it would fine, but as it cannot fine, what owners could do, they could meet their treatment agents and request their rights. And if companies are not prepared to do that, and we are the world champions in judicialization, because I can say that because I spent 25 years of my life in a justice court, and I left the court to devote myself to data protection, but no one doubts that owners will seek, will go for lawsuits. And there are movements promoted by professional entities that mobilize to create mass claims, because the controllers will know that the companies will not be ready. And when it comes to the judiciary, we never know exactly what can happen, because each justice, each judge has their own understanding of the law. So if there will be reimbursement because the legislation was not complied with, or if the damage needs to be proved, I mean, this is completely uncertain points, and it will depend on how the judge, specific judge, looks upon that case. So in spite of specific issues regarding penalties and fines, it's important that Brazilian companies understand that here in Europe, the, the owner's activity has been recurrent. I'm not talking about just judicialization because the situation is a little bit different here, but there were some penalties and some fines due to non-compliance. So I always say, why do you have data protection systems? Who should they protect? Who is in the center of it? The owner, the data owners. And their needs need to be met, need to be concerned about that. And the second aspect I'd like to discuss is that here in Europe, we understand, I don't know if you have the same perception. I mean, if my colleagues in London have the same perception. Reputation aspects, they are relentless regarding companies. So my father is 91 years old, and he's very smart, he's very active, and he says that he used to say, I remember once I crashed my car and I was complaining because I would need to spend money to fix my car. It was my fault, and I need to fix my car and the other person's car. I was complaining all the time, and he told me, daughter, do you have the money to fix the cars? And he said, yes, I do. Well, if you have money to fix it, it is cheap. I mean, there's no problem. And this applies to companies as well. When Facebook was fined by FTC, they celebrated because they managed to solve, let's say, to have an agreement with FTC. And however, their reputation suffered a major blow. I mean, Facebook suffered this blow. And till this day, and I believe some years from now, Facebook will lose this protagonism to other companies that better or who are more compliant, let's say. So when the companies suffers leaks, it's possible, yes, but if they are not ready to face these leaks, to work around them, if they are not engaged to guarantee compliance, if they do not have a clear relationship and honest relationship with the owners. If they are unable to meet the owners' needs and requirements, these companies will suffer major blows. They will be seen as disgraceful companies on the eyes of the consumers. And regarding responsibility and accountability, especially when there is outsourcing, when the controller needs to hire someone else, like a service provider, to perform part of that service, it's clear that if this controller, normally bigger companies, not always, but usually bigger companies, so if they need to hire a company, a smaller company, the first thing they will ask is precisely that: how is your compliance regarding this regulation? So companies that cannot demonstrate, that cannot show the controls that they are concerned and they are engaged in terms of saying, yes, yes, I have everything done, I have done my homework. If these companies don't show that, they will be left out. It won't be possible for them to close deals. So André, this issue on data is very interesting. You can see in a multiple way all the consequences resulting from non-compliance. Obviously, the first aspect is that data protection is a fundamental right. This is clear here in Europe, in the European Union, and in Brazil. We have a new the 17th constitutional amendment proposal to add another right to our federal constitution. So there is this rationale of honoring this fundamental right. And we also have this rationale of not only honoring this fundamental right, but also materialize and process requirements, establishing a transparent relationship between agents, treatment agents, service agents, and owners. And we also have the business aspects. Well, if there are problems, companies can potentially suffer the impacts on their reputations, a negative impact on their reputations. The Americans are, they measure this, the rep track, companies rep track, and they can see that many gigantic or giant American companies could never get back to their previous reputational level after suffering these blows. And now, regardless of when the law will come into force, if Brazilian companies are not able to demonstrate, especially those companies that work as controllers typically, if they cannot express, if they not demonstrate their compliance, they will not be hired. I'm here in Portugal, it's a small country, and I personally know companies that were already swept from the market because of this issue. So this would be my considerations. It's very interesting to, I mean, due to the singularity, to observe these issues. And let me talk about an additional aspect. In Brazil, we have this judicialization. So it's better to prevent. It's better safe than sorry. Thank you very much.
Excelente, Viviane. Muito obrigado mais uma vez.
Excellent, Viviane. Thank you so much for your presence. I think you just said everything and you solved it in the end. These legislations, these regulations, not only the LGPD in Brazil, but the GDPR internationally, and then the CPA in California, they bring the concept that you have some sort of audition coming from the state. You cannot be just in compliance. You have to prove that you are in compliance. So this is quite interesting, and it's I like it very much. Thanks, Viviane. I'm going to give the floor to Punan now. Punan, how do you see this perspective, the perspective of people that are working, in a multinational that is in the UK and South Africa and so on? How do you see that? The floor is yours.
Thank you. So the perspective I see for the UK and Europe and South Africa and other countries that are implementing GDPR is that I think that they see GDPR generally as a good idea. It creates harmony amongst a variety of member states. There's one piece of legislation that's used across those member states that share information between one another. So I think that generally they see GDPR and the kind of harmonization of the legislation as a good thing. I think there's a lot of nervousness generally because the fines are so high. So there's an implication, which is that companies have a lot to lose if they don't get this area right. And then additionally, I think that it is actually a very complex area. The whole point and I suppose the beauty of the GDPR and the new legislation that is focused on data protection is that it's very principles based, because you can imagine you can't have a very structured set of data protection laws that are supposed to be implemented within, for example, one small company, which could have a very different look and feel to a very large company, or for example, a private sector organization, which could be entirely different to a public sector organization. So I think that's how they generally view GDPR. I think that there are some negative perceptions of it though, as well as some positives, as you can imagine. I think the positives I would identify, for example, are that data protection now is taken very seriously, and that has to be a good thing. Also, another positive is the fact that the data protection legislation is very focused on data subjects now, which again is a very good thing. The negatives are, for example, that there are very small companies out there that don't have a particular data protection structure, and so they struggle with it because it's not only complicated, it's very costly. I think a key area I would say is that during the run up to GDPR, so up to 2018, there was a lot of impetus on the area. And then all of a sudden, it kind of stopped. The minute GDPR was implemented, it suddenly stopped. So I question if it really had the, if it really achieved its ambitions. I think just moving on from that, there are a few other points that I just would like to set out, which I would say are positives about the GDPR. For example, in the UK and EU, there have been over 300 fines and penalties that have been handed down so far. The most active regulator is Spain, which has given 115 enforcement notices. The next highest is Romania with 32. And then you have the UK, which has a number of very small but very high fines, such as British Airways, which had a fine of £183 million. So clearly these sorts of fines, they are a good thing in the long run, because it shows that companies are being made examples of if they have lax attitudes towards data protection. And then obviously it's a good thing for the Treasury. But as I was saying just now, the negatives are that first of all, the GDPR has led to a significant increase in reporting to the ICO, which is the data protection enforcement body in the UK, and that means that their workload has increased significantly. Secondly, most fines are not the €50 million fines. They're actually quite small. They could be in the €5,000 fines bracket. So, you know, again, there's a question, does GDPR really have the teeth that we were led to believe that it would have? Another point I would say is that whilst it is obviously very beneficial to have the changes and the increased reputation of the GDPR, the problem is that there are some quite confused cases that are coming out as a result of it. For example, Max Schrems. So the question mark I have is, can we carry on sharing personal data with our American partners using the standard corporate clauses, the standard contractual clauses, or do we now have to start using the binding corporate rules, which many people have said to me they find very cumbersome? I think I would conclude by saying that I think it's questionable how much data protection is really taken seriously, even now. But I think given the challenges that are being brought about now by the contact tracing app, which is being implemented globally in response to the COVID-19 crisis, and the desire to generally share more data more readily than before, I think a keen understanding of data protection is critical. So I'm of the opinion that enforcement bodies should do more in order to create awareness training. And I'll hand over to Dan, I think, who was going to say some words.
Thanks, Pam. Andre, do you want to do any transition? Should I hand back to you?
Sim, muito obrigado, Punan.
Thank you so much, Punan. And I'd like to give the floor to Daniel right now. But before that, I'd like to reinforce, actually, I mentioned in the chat, if somebody wants to ask questions now, we have the Q&A, little list there, the little chart. So then you can write there, and then in the end, we're going to, make questions. And so the people that are the members of the panel, just go ahead and answer. I'm going to read these questions in the end. Thank you so much, Punan. And now, Daniel, the floor is yours.
Thank you. Let me just share my screen. It'd be great, actually. Maybe, Andre, can I just check that you can see that all okay and the screen's coming up fine? Can you just give me a nod? Yeah, fantastic. Wonderful. Following on from Vivian and Poonam, what I want to do for you is really give you an applied view. So after following on from the lawyers, just to be really clear with everybody, I'm not a lawyer. I've spent about 20 years around the technology and data space. And my role here at EXL is very much a consulting role, helping clients achieve compliance with regulations such as GDPR. So yeah, my focus will be very applied and very sort of framework driven. There's really 6 points I would like to 5 points I'd really like to cover off. First of all, what are the current challenges we're seeing with GDPR and set up beautifully by Vivian and Poonam around the data inventory. At the heart of GDPR is the natural person, be that an employee, a customer, and normally we talk about customers. But at the heart of that is the person, and we really see that there needs to be the compliance framework and the risk management framework built to support the compliance. Secondly, cross-functional approach. The approach doesn't work without the DPO, the Data Privacy Officer, the CDO, the Chief Data Officer, the CRO, the Chief Risk Officer, all working together, and others, and I'll come on to that a little bit later, and others working together. Thirdly, we see what's been working is really a hybrid project management approach. So neither an agile approach nor a very structured waterfall approach. We see that a really hybrid model has been working. Fourthly, around the controls and measures, whilst some discovery, and I'll talk about the discovery elements, learning elements, but getting the controls and measures right, getting that design right for compliance is vital. And then lastly, I'm just going to step back a little bit and talk about some overall trends that we see in the market, and talk about why we see the market moving towards open source, and part of the reason why we've gone into partnership with Pontus. Just before I do that, I'm conscious of many people, and I literally just spend a minute on this, on who EXL is. I'm conscious Puna and I are speaking, and not everybody may be familiar with EXL. So just very, very quickly, we're a NASDAQ listed organization. We're over 2 billion in market cap. Some say we're the biggest services company most people have never heard of. We're nearly $1 billion in revenue, so our 2019 numbers that were reported relatively recently nearly touched on $1 billion in revenue, 30-odd thousand people globally and delivering in over 61 countries. Two core services, and the division that I sit in is the data and analytics division. The first two that you see there focus on enterprise data and analytics services, and plus we do operations management, which is really around that data process outsourcing or knowledge process outsourcing. Again, data and analytics, probably if anybody's follows Gartner's reports, you'll notice that this year we made the Gartner Magic Quadrant for data and analytics. And our country coverage, as I said, is 61 countries. I will flag, I know we've got a predominantly South American audience, Brazilian audience. Unfortunately, we don't yet have an office in Brazil, though I keep putting my hand up to open the office. I'd love to go to Sao Paulo, but unfortunately, that's not there yet. We're currently in business out of Colombia. Now let's go to the crux of what I want to talk to you about, which is GDPR and what we've seen around getting clients compliant. So first of all, we think about the traditional compliance and risk management model, or the 3 lines of defense over on the left-hand side. And you don't necessarily need to be familiar if you're not familiar with the 3 lines of defense model. It's not a problem. And I've specifically used a public known reference there. So the Institute of Internal Auditors, you can download a paper. There's a link there about the 3 lines of defense. But what we think about is the traditional first line being business, second line being risk management and compliance, and the third line being the internal audit function. And what we're seeing is those 3 lines of defense really needing to come together. As I said, as Purnam's talked about, needing the DPO to the data privacy officer in, as Vivian confirmed, which will be in LGPD, as it is in GDPR, sitting in that second line of defense around compliance, but working with the business and working with audit to make sure that it all works in concert. But the key thing that we're seeing that needs a common language and a common inventory across those 3 lines of defense is that customer data. And of course, insert any other natural person there as the GDPR defines it, which could be an employee or any other natural person, a stakeholder in any way. And here I use customers as we're all familiar with the customer, but managing that data asset and building that data asset inventory to enable us to track and manage that data. And the example that everybody talks about, I don't know whether it's a common saying in Brazil, but in Europe here, everybody's using the term data is the new oil. I'm not sure how many oil companies don't know where their oil is. You know, generally oil companies know which tanker or which tank their oil is in, right? How is it that if data is the new oil, not everybody knows where that customer data is? And I think that's, to me, the message here, right? Is in order to enable those 3 lines of defense to work effectively, you need to know where the oil is. What do we see? We've built a solution to address this problem. We've built a solution working with Pontus Vision its working name is called Unity. And we see the business objectives of that is, first of all, managing that data asset, tracking and managing that data asset. And of course, the key element of that is customer data or the natural person data. But it spans across structured and unstructured data, right? And I'm going using customer, and you'll see I'm using customers to be the model that I'm talking about in terms of the natural person. And second of course, GDPR compliant. There's a number of measures, there's a number of principles as Purnam and Vivian are spoken about, that we need to be compliant with. Right? So how do we achieve that compliance? But then there's the one that sometimes gets missed, and that's that data and policy impact. As I said, there's a cross-functional collaboration that needs to be brought together to get compliance, right? So when we say policy impact, we don't just mean privacy policy. Of course, you'll need one of those as well to be compliant. But actually, what about risk management? What about data governance? What about data management? All those policies. Cyber risk is another one that we see is playing a key role. So we actually talk about policy impact, not just privacy policy, but all sorts of policy need to be impacted and need to be thought about in terms of how to achieve compliance and how to get the 3 lines of defense working effectively. So in terms of our solution, the Unity solution, and again, this is not a sales pitch, so I'm only going to spend a few moments on these and get into the approach. But we really see that bringing together the structured and unstructured data sets, so the CRM systems, the HR systems, with the email systems, semi-structured, or indeed the file shares, SharePoints, etc. Right? Needing to bring those together and find those customer data assets and build the inventory of customer data or natural person data across wherever that sits. Then to remediate that data that's outside of policy, and I'll come into some of those examples later on. And of course, do the functions that are required to stay compliant, like privacy impact assessments, like DSARs, to make sure that you're completing those functions, the principles, to stay compliant. Now, the bit that we like, and I'll come and talk about it, the reason why we've partnered with Pontus is around the open source nature of it. We really see some trends in the market that are pointing us towards an open source solution. And what's more, that the capabilities of Pontus to graft onto a network and be non-intrusive is part of the capability we like. Let's now focus on the core activities. All right, so what activities would you perform? So, and I'll move around in a clockwise manner and starting up with A around monitor. So first of all, that client data infrastructure, right? So the applications from the BI servers to the email to our client data store, customer data store, or CRM system, or whatever it be. To monitor that and look at where that data is, regardless of its format, whether it be structured or unstructured, is critical. Then to pull that data out, to be able to have the right connectors to enable the solution to extract it. Thirdly, to track it. So to bring together those data sets and identify the natural people in those data sets and really build an inventory about where every atomic element of that data is. So from a customer's date of birth to their address and to those elements of PII, personal identifying information, which is the sort of acronym that everybody's been using over here, to really understand where that data set is and build an inventory for it. And then lastly, the obvious step is to comply. So to make sure that you've got data sets there that are within the regulation and within policy. Right? So have I got data that's 10 years old that I no longer need out there on a customer that I'm no longer doing business with? If so, why? Is it an asset or is it a liability? And I think that's the way we need to think about that. In terms of our approach to achieving that, we see 6 steps as critical. I'm going to focus on the middle 3. To anybody that's familiar with the project management methodology, none of this will be unfamiliar, but I think it's the blending, as I said at the start, of waterfall and an agile approach that really is the key here. So let me just walk through these 6 stages. So first of all, POV, proof of value. So the key bit here is that the value of the solution of being compliant almost speaks to it for itself. Why would you need to prove the value of that? Well, it goes back to exactly the thing I was talking about before, and needing a cross-functional approach to compliance, right? It can't be just be the DPO, the data privacy officer, nor the CDO, chief data officer, nor the CRO. All those people need to come together, and that proving of the value to each one of those stakeholders is an absolute critical part. Often we'll say to clients, please, I know you want to kick off your mobilization, you kick off your compliance program, but let's actually run a POV, proving out the value to each of those to get that buy-in in that cross-functional team. Mobilization, all the good program management stuff around setting up roles and responsibilities, etc. But moving into the middle 3 steps that we see as really the crux. First of all, it's the configuration of a solution. Now, maybe Pontus, you may choose, but the fact that I would suggest that you never get that right out of the box, and it needs to be iterative. It needs to be an agile approach to make sure that you're actually getting that configuration right. The next stage, stage 4, is around that data and policy impact. As I said before, it won't be just the privacy policy that's impacted. It will be your data retention policy, your information security policy, your risk management policy, right? All those policies will need to be impacted, plus the data. How do we impact the data sets? Where are they? Do we have data sets out there that we weren't aware of? The 5th step around remediate, bringing those data sets that aren't in compliance back into compliance, right? Do we have a data set on a customer that we've been doing with, that we did business with 10 years ago, that's still on our file share? Well, if so, why? Why would you need that? Is that inside data retention policy? If not, why not? And remediate it and get it out there. And we see that remediation really falling into 2 categories. First of all, you'll find the stuff that's blatantly obvious, right? That's clearly out of policy and not even needing consideration around whether it's in policy or out of policy. But then we see the tier 2 stuff, the stuff that's really the trickier questions, right? How are you doing? Do you have data on a customer that you did business with 10 years ago that you're actually maybe expecting a legal suit from, or are currently in a legal suit with, right? How do you treat that data? Is it part of the discovery? So there's trickier questions that you will discover as you remediate and go through your process. And again, I'll make the point that those 3 core steps are iterative. You will be executing those 3 things in parallel as you go through. And then lastly, moving that structure into steady state. So to Poonam's point, the key challenge that we see some clients have who have done this approach while not adopting a solution like Pontus or some equivalent solution is the cost of compliance. Right, the prohibitive cost of executing and keeping spreadsheets, etc., up to date is unreasonable, and things like executing data discovery DSARs where natural persons have made requests. We've spoken with clients who have not adopted solutions, throwing six-figure numbers around for the processing of a DSAR. A data subject request. So being able to build an operating model that and execute in a cost-effective way and achieve compliance is critical. Andre, how am I doing for time? Am I still within bounds? 2 more minutes, fantastic. Let me just close out by saying why have we partnered with Pontus for our go-to-market GDPR approach, and why we see success for clients with that approach. And there's 10 reasons here, but I don't want to talk about all 10. I'll just focus on 3. So first of all, partnering with a solution provider like Pontus has enabled us to stay focused on what's our core. Our core solution is services. It's not building software. And bringing an open source solution like Pontus has enabled us just to go directly to market and put that wrapper around it I talk about, bringing our capability around remediation, policy, and execution to the fore and not focus on software. Second thing, and part of the key conversation we're having with clients, is you need a solution that's multi-cloud, and what's more, can handle a mix of cloud and on-prem. It can't be just an AWS, even when clients are an AWS client, right? Their predominant cloud provider is Amazon Web Services. We still see the value in having a multi-solution that's not bound to a single cloud vendor. And I'll skip the others, but I'll go to 4 on the far right corner around the open source solution enables us to have no vendor lock-in with our clients. So we're very transparent with our clients about the solution at the heart of Unity, and the conversation for us has really been about, if you don't like us, you can always pick that solution up and move it as it's an open source solution. So that's been key for us. And in my last minute, I just want to talk about some trends, again, that drove us to really go to market with the Unity solution and go to market with Pontus. And first of all, obviously, it's the deployment of and acceptance and development of automation and artificial intelligence solutions, right? The ability to do natural language processing to find those PII, personal identifying information elements within unstructured data is only accelerating. Second of all, the adoption of open source. No longer do we have a conversation with clients around, we don't do open source, it's a bit of a risk. Linux, Python, Docker, all those solutions are now industry strength solutions, and nobody has two bones about adopting an open source solution. And then lastly, the need to have cyber insurance and data privacy insurance is growing at a serious clip. I think the two quotes there from The Economist is critical. First of all, around the breadth in the top article on the top right, around the breadth of coverage. I mean, it's Aon's quote, but it's 58% of property, plant, and equipment, i.e. those tangible assets are covered, but only 15% of firms are covered for cyber. And then lastly, the growth that Munich Re are talking about in that market, it only tells us that firms are looking to cover those risks more closely. Andre, that's me. Can I hand back to you now?
Perfeito. Hold on.
Perfect. Thank you very much, Daniel. It was excellent to listen to your perception and this framework that you explained, how these companies can tackle these different pillars. We know it's not easy. You need to come up with a multidisciplinary or cross-sectional approaches. Your presentation was very rich in this aspect. Thank you very much. So now let me call Leonardo Martinez from Pontus Vision for his presentation. Welcome, Leonardo, the floor is yours. Good afternoon, everyone.
Well, just to kind of give a background of Pontus, like Andre said in the beginning of this meeting, it is a company, it's an Anglo-Brazilian company. We are in a very funny, interesting environment. We entered the market helping the English government with the GDPR, and we made the transition to Brazil to help with the LGPD. So what I would like to approach today are some of the lessons learned with the GDPR and how we are seeing the cultural differences between the GDPR as far as deployment. I mean, how you really take a automation tool. So we are actually seeing the cultural differences between Europe and Brazil. So the biggest lessons that we learned, not only in Europe, but also in Brazil with some interactions that we had, is in some of the approaches that we usually have in the projects, like Dan said, for instance, you have a cycle of projects that are iterative. So what we see, one of the contrasts that we really see between the GDPR and the LGPD is that in the GDPR, you had a market that was much more mature. Many countries with different legislations, like Poonam said, the GDPR was good and positive in that aspect to unify all of that. But on the other hand, because of that, so you had some basis. And I think the biggest difference is that comparing to LGPD, because most of the companies will start from zero, I mean, draft, definitely. They didn't have anything previously. So what we think quite interesting, the difference in the approach between Europe and Brazil, the LGPD in Brazil, is that on one hand, we think it was maybe a little bit of a marketing from the companies that are financial, are funding the tools, but the discovery itself. So what we notice is that there is a tremendous focus in discovery. I mean, discovering data, the data sources of that company. And what we think it's nice too is that with that, the common sense suffered a little bit in approaching the processes, because we saw that worked very well at the GDPR is that we take an approach in which you take the areas that are riskier in the company, so a CRM system or the human relations and payroll systems that are already known. I mean, how are you going to spend time in the beginning of the project doing that, looking for data bases or data bank that nobody ever heard about? So that's quite interesting, that, you know, this contrast, I like to say. And something that we've seen also is that the analogy that I make is it's like a relay race. You start and then you take the bat to the other one and to the other one. So it's like passing the bat. What we see that the bat that is passed to the tool usually is too late. You know, it's passed with a little delay. So there's a lot of important or main pillars. There is the legal team that will analyze, you know, the legal basis or the juridical stuff that you must have, and how you're going to treat that data. Also, you're going to have a consultancy department to help that too, and maybe you're going to have a tool to automatize the more robust or the parts that have more volume. And what we noticed in Brazil is that for many times we get after the consultancy and the legal approach, you have problems because you lose a little bit of the value, you know, of that initial consultancy. When you start documenting or reporting a process, for instance, you are in risk of being obsolete after that, because if you take too long in documenting the process and then treating the data or reporting the data, putting it in a catalog. So it's interesting. I think I like to say that this part of the approach is quite nice, quite interesting. So we have to be closer to the consulting and also with be together with the legal offices, the law offices, and approach the clients, the customers earlier. So any tool that they choose, they should choose it as soon as possible, because that makes a big difference. Because we shouldn't be wasting a lot of time with discovery. As Daniel said, it should be iterative process. You should catalog all the procedures and all the processes of data, and then start already getting the info and putting it or adding it in the tool as soon as possible. Because if you take all the known databases that you have and all the bases that are structured already, you know, before you go to the most exotic parts, I think it's better, because sometimes you think, oh, this is normal, this is usual, but no, people are focusing in the most exotic areas because they're like risky. They don't want to be negligent, but they actually are. This is an analogy that people were using in the beginning of the GDPR. Oh, it's going to be a project just like the 2000 project. Oh, you know, the world will end in January 1st, 2000. But in truth, we see that no, you know, it didn't happen and it's not going to happen. CCPA, LGPD, GDPR, all these legislations, they're here to stay. Nothing is going to end. I mean, the use is continuous, it's ongoing. So the tool that you pass, it's going to, I mean, this relationship will be very, very lasting. During all the compliance process. So I think it's worth it because the tools are being chosen, and usually it's open source and it's modular too. You can put the models and you can insert them as the time goes. So actually it motivated me to do as part of the British, I mean, the English government is open source. So if the company wants to use different solutions and incorporate with ours, it's good too. So like Daniel said, it's one of the advantages, one of the good practices, you know, good corporation habits. So I think these problems, they have this interesting because the Brazilian culture is really nice too. Like Daniel said, in Europe, people don't really care for open source, but in Brazil, we are still a little bit, we saw some resistance in the beginning, but then the benefits at the end of the day is good. I mean, the reuse and so on, and to be modular. I think another part of this lessons learned, which was really nice too, like Dan said, the requirements in the GDPR. I mean, in some cases here in Europe, they were nice because the company or the corporation was previewing that it was going to have thousands, but it didn't have any. But then the opposite also happened. We had a case that I was actually being partners with Daniel. They translated to reais, more than 1 million reais in one requirement, and then which another collaborated, and then actually they didn't take care of that, and they spent a lot of money. And also, you know, the banks in England are receiving thousands and thousands of requirements of orders, especially personal banks. I mean, people's banks, you know. So because sometimes you have companies, law offices that are focusing problems that the banks might have with the consumers, with the customers, and seeing that this is a funny trend. And on the other hand, some other companies were expecting a lot and they received much less than they thought. So this process in terms of what happens, you know, after that, after the law, not only the DSARs, but also data relations and so on, it's important to be considered when you're solving the compliancy problems. It's important to think about that, because if you take too long in passing the bat in that relay race, I mean, definitely you can miss or you can lose the whole race, and there's nothing worth it to show in the end of the project. Or maybe you can spend too long to actually have some value, especially in the automatization. And then last, I'd like to share, I don't know if I'm going to be able to share one of my slides, but just to kind of show that you have a benefit in the law or with the law. So one image that I like to show pretty much is this one. Data governance, it's pretty much transforming or changing a mass into like an information mass into something very well cataloged, very well separated. So this is one of the positive sides, you know, in having a legislation as GDPR. Like Daniel said, data are the eyes. I mean, it's the oil of the company. So you want to know where this oil is. So if you have information that are all crazy and messy, if your company depends on those, on that information for their daily routine, it's going to be much easier to have a beautiful library, very well organized, and so on. So I think these are my lessons about, you know, GDPR compared to LGPD. Fantastic, Leonardo. Thank you so much for your perceptions, for your considerations, and for bringing this rich vision of yours. So now I'm going to open for questions already. So then we can do this whole thing in a more dynamic way. So I'm going to read some questions, and then you please feel free, each of you, to answer the way you want, or to make comments, or even bring their comments. So, you know, it's going to be more dynamic. And our audience, please, you guys, feel free to send more questions. You have that session of Q&A, so then we can advance in our discussion here. I'd like to actually, we've seen lots of questions already about, especially here in Brazil. And then Viviane and our colleagues, our Brazilian colleagues, can say, when does a company need to define if she's going to have somebody, you know, a GPO, a privacy officer? Do we have to need it? Does this company need to have that? Or can it have a compliance team that's not necessarily going to be that one guy, specifically that one officer? Because we have two processes. We have the process of having the compliance journey, and then I understand that then you're going to have a process of maintenance. I don't know who said that. I think Dan mentioned, right, the controls and that, and the monitoring and the execution of that, what was implemented. So following the questions that we have, Eduardo said, he brings that question about small and middle-sized companies. He mentioned that he sees that the LGPD not necessarily brings different treatment among these companies, no, small or middle, but GDPR. Do you guys have some sort of differences between small and middle-sized companies compared to those big ones? And so,
Andre, I can answer that question for you. So,
eu acho que eu posso.
in the with regard to the GDPR,
Bom, em relação à GDPR,
is to have a data
a
protection,
ideia é ter encarregado de proteção de dados,
or if you are an organization that
for uma organização
sensitive personal data. So,
que trata de dados pessoais, isso é muito importante.
to have the,
É crucial ter DPO, um encarregado de proteção de dados. Muitas outras empresas podem contar com algum outro desses encarregados. Thank you, Punan. I think your mic is a little low. It was a little hard for me to understand. Your mic, your volume is a little low. So let me get back to questions. If you want to go back to your answer or to rephrase your answers, I don't know if people could understand, but let me make some more questions, a couple of questions from our participants, and then you feel free to answer them later. So Cleberton Soares asks you, how can you see the polls and I mean surveys, especially academic surveys, academic research, PhD research, master's degree research on GDPR? Do they involve companies and the academia? I mean, is this connection strong in Europe? Giovanni Werneck asks you, how do you see the implementation of LGPD in public organizations? Maybe Viviane could answer this. Well, I had seen this. Well, you can finish reading the questions, because I would like to make a connection regarding DPO and then public organizations, all right? Public entities, all right. Okay, there is a question to me, but I am the moderator today. Maybe I can later answer this question. Viviane, how do you see CAD, the CAD issue? CAD is the organization that monitors competitiveness regarding, it relates to FTC in the US. So CAD monitors competitiveness. So maybe, what about CAD is being the regulator of privacy data? And I have a question, and I would like to listen to Daniel's answer and Leonardo's answer. Well, it has more to do with the technical aspects. We have the processes, and we have the technology, and you have the people, right? However, how do you see, what is your opinion about data monitoring? Because, well, we have the tools to monitor data within the software that make part of a HR process, for instance. An HR process can rely on several pieces of software, and then you can look at all of this software and guarantee they all are compliant. In the payment department, I believe you can guarantee the CRM compliance and also the compliance of other software. So how are companies looking at people who create within a process their data management? I mean, consider a Word document, a Word file that is not part of that, but the employee prefers to create a list with the employees' names for the HR, or somebody who takes care of payments, they prefer to use their own Excel program because they think it's more practical. Even if it's the payment data are into the system, they know that they will not make any mistakes if they use their own Excel spreadsheets. I mean, how do you see this dialogue, this connection, so we can guarantee, so we can make sure the whole company, or the company as a whole, is compliant? So let me stop here. And we have a question sent by Amanda, which is, I believe, or do you believe the major concern has to be the owners, right? I mean, to serve the owners, right? Should we have a tool to that? What about the DSR regarding the data owner? Could it be automated? How do you see that? And then can we follow the same order that we started? So first Viviane, and then Ponan, Daniel, and then Leonardo? Can it be? Can we do it like that? Okay. So Viviane, the floor is yours. All right. Now let me try and optimize our time here. As I mentioned, there are some major brutal differences between GDPR and LGPD. And one of these differences has to do with the hypothesis to appoint the DPO. And our DPO, the Brazilian DPO, has more has softer requirements, let's say, if compared to the DPO in or within the framework of GDPR. And the Brazilian DPO receives orders from the managers. And it's not like that in the GPR. In the GPR, the DPO is completely autonomous. So LGPD today, if you read the text of the law, you will see that it's mandatory that all controllers appoint a DPO. This is a general rule which will not remain, will not be lasting. And the rationale had to do with, instead, I mean, the specific circumstances of appointment came from the legislative power. They should come or should be defined by the authority. So this is why it was defined that all controllers should appoint a DPO. And then the authority prerogative would be in charge of waiving or dismissing this DPO. So as you said, oh my God, what should I do? On one hand, I need to comply, but on the other hand, I don't know whether I would be potentially waived. Should I appoint? Should I not appoint? What should I do? We cannot know at this point. We do not have an answer regarding that at this point. My advice is that the company runs an auto-analysis, a self-analysis regarding their data treatment profile. Anyways, we have defined as a mandatory circumstance under LGPD regarding public entities or public organizations, that it's mandatory that public organizations appoint a DPO. So we have to but we have two other requirements at LGPD which are not defined yet. So I recommend that companies better understand and better know this hypothesis, this of, of appointment. And if they fit in this profile, it's okay, but it depends on resources and anything else. But if it's possible, in fact, they should adopt they should move or they should work under this spirit, because the DPO will be in charge of all the deployment process, and this will provide a guarantee to the companies themselves. And what about this criteria? I'm not going to go into further details, but let me say that companies will have to research that volume of data, that data volumetry, and also sensitive data or special category data under this law, and they should monitor this data. And if they realize that they fit under this scope, I would recommend that they recommend this. If you're in doubt, please stick or comply with the more or the most conservative approach, or the most conservative requirement. This would apply to all laws, to legislation. So we still lack the authority, but as we do not have an authority, we have some other organizations that are implying that they should have access to impact reports. There are some authorities that have been requesting specific diagnosis on how data is treated or shared. So although, I mean, sometimes companies think that we lack the authority, no penalties, no fines, only next year, a year from now, but it means nothing in practice, because companies are already subject to it. I mean, under the perspective of the owner's data in other aspects, but they are subject to fines. Like Facebook was fined by Senacom, the National Department of Consumer connected to the Ministry of Justice, because due to that episode involving Cambridge Analytica. So if you can find a relationship with consumer, you can invoke other entities like Procon, Secon, and the prosecutor's office. So in practice, we should stick to a conservative approach. And regarding public organizations, there were two questions in the Q&A session. One regarding how our public organizations are arranging this. It is a challenge because they need to rely on budget preview. It's hard to understand some basic concepts, including the very position of the DPO within the public entity, and public entities can never object to the fact or say or state that they do not have the necessary budget to do that, because a law is a law and it will require that. The second question is regarding the DPO could be the ombudsman. We don't know. This will depend on how the authority will construe the law or construe this freedom of function accumulation. GDPR allows that, provided there is no conflict of interest. So an ombudsman can be a DPO. But you, as a public entity, should clarify whether there would be conflicts of interest or not. In Belgium recently, in a private company, they were discussing about the DPO and compliance officer and whether they could be the same person. One authority can understand it in a different way if compared to the other. But I think it's better, it would be safer in a public entity, as in many courts too, I've heard. It would be better to have a DPO that is autonomous. I mean, that is specific, that serves specifically that title. Punan, welcome, and the floor is yours.
Hi, I hope you can hear me better now. I'm not sure if that's the case, but let me know if you can or you can't. Excellent. Okay. Under GDPR, with regard to having a data protection officer or not, there is an obligation to have one if you are a public sector organization or if you are processing large scale quantities of special category information. If you don't fall within one of those two categories, then there's no legal obligation on an organization to appoint a data protection officer. Having said that, it would be sensible to appoint one, because as you can imagine, the obligations that you have under the GDPR are complex, they're convoluted. Many people say that the way that the GDPR was drafted is in a way that's not particularly user-friendly at all. So it takes somebody who is a data protection officer, who has got the experience of a data protection officer, to be really in control of that obligation and to make sure that all of the requirements are fulfilled. In terms of the sort of person that you would have as the data protection officer, the GDPR isn't particularly prescriptive, so you don't need to have particular qualifications. You just have to have experience of data protection, and that isn't a qualification. I mean, it's just experience, so it could come in any format. So the reality is that you have a variety of data protection officers from a variety of backgrounds. They can be lawyers, they can be chief finance officers, they could be CISOs in the IT sector. I mean, there's a multitude. But the key is that within the organization, the data protection officer, actually, as Vivian mentioned, has got to be independent of the rest of the organization. So if you identify that there's been a data breach, you need to feel capable of contacting and self-certifying to the ICO or the relevant data protection authority that there has been a data breach. You can't be in fear of your livelihood. So I mean, there's lots of there's lots of obligations then that you have as a data protection officer. You have to ensure that the organization itself is trained fully. You have to ensure that you have a kind of, you get to grips with what the organization is doing generally with regards to its compliance with data protection. I mean, you can't be in 100 places at once as a data protection officer, and I can certainly certify that point. But you do need to have an understanding generally of what's going on within the organization when it comes to the organization's general attitude towards data protection compliance.
Muito obrigado, Poonam.
Thank you very much, Poonam. Now, let me ask Daniel to answer the questions or make your comments, please.
Thanks, Andre. I think I'll probably pick up 3 of the questions that got asked that I think I'm best able to answer. Just for instance, I'm excluding the public sector question as I personally don't look after public sector clients, so I can't comment. First of all, somebody asked about academic involvement, and we've seen that as critical. So we have actually established a relationship with the University of Prague, Economics University of Prague in the Czech Republic, and we've been collaborating with them for over a year now in getting some of their PhD and MSc students to look at this particular problem. So whoever asked that question, I couldn't agree more, and I could only encourage in Brazil and LATAM to take the same approach, because as Vivian and Poonam have pointed out, there's still so many unanswered questions around privacy, its need for collaboration with risk management and all those questions, but not least some of those technology trends we touched on. There's so much research to be done in this space. I couldn't encourage that more. We've had some really productive conversations with the Economics University of Prague. The other one I wanted to pick up was all the data types. I think, Andrea, it was your question around how do you deal with this challenge of apps with structured data sets versus unstructured data sets. And to me, I actually, the guy or girl that you talked about who actually has created a process that is effective of tracking the payments they made, you gave the example between the payment system and the spreadsheet. I think the key thing here is, and I'm really trying hard to make this not sound like a sales pitch, but part of the reason why we went with Pontus as a partner in this is because it tracks both of those data sets. It tracks the structured in the app, and let's assume it's some sort of payment system, right? Within that structured data set of the PII and the special category data that Poonam was talking about, with the connectors that it has the ability to capture that. But also it has the ability to capture the unstructured data set that's being created and worked. Because to me, if the controls restrict the capability of somebody who's core to the business doing their jobs, the controls are designed incorrectly, right? Now, of course, if that data has been put at risk for unnecessary reasons, that's something else, and that's what the control should be designed to capture and protect against, the preventative controls. But to me, the whole point is to let the business people get on with their jobs. Let sales guys and girls do, and have part of my role to be a sales guy and girl. We won't talk about the customer, my Christmas card list of all the PII of my key clients on my laptop, right? Because I want to send my clients Christmas cards, right? Now, of course, the PII contained in that spreadsheet, who would like to think? But of course, it's protected. It has endpoint controls around it. It's encrypted, et cetera, right? So it certainly shouldn't. Those controls shouldn't be around stopping people doing their job. And then the last question, which I think I am able to comment on, is the DSAR, the Data Subject Access Request, which is a core process within GDPR. Can it be automated? Absolutely, and we are working with clients to do that all the time. Working with Pontus to automate that process as much as possible. Are we seeing 100% automation levels? No, we are not. Of course, we are talking about pulling across structured and unstructured data sets, customer data reports, or stakeholder data. I keep using customer as an example. It could be a previous employee or current employee. Are we seeing the capability to pull those data sets together? Absolutely. And that part of the thing that Poonam was referring to earlier, the cost to comply, driving that cost down to comply, is absolutely part of having an automated solution, because doing a DSAR manually, as I referred to in my presentation, we've had some clients talk about 6-figure sums to do a single DSAR because those systems haven't been, those solutions haven't been put in place. I'll hand back to you, Andre.
Obrigado, Daniel.
Thank you very much, Daniel. Muito obrigado. Thank you very much. Now, Leonardo. Leonardo, the floor is yours.
Vocês estão me ouvindo?
Can you hear me?
Tá. Então, a resposta, as
Well,
perguntas que eu queria
the answers I would like to answer.
o Dan comentou pouco.
I mean,
Eu queria
Daniel
saber
talked a little about that. Let me
mais ou
just
menos
add some comments.
então, por exemplo,
As
começando
far
com
as
a
challenge go,
pergunta
let me
sobre
talk about the
então,
question on
numa
data,
planilha ou
which
num
are in a
documento de Word.
spreadsheet or in a Word file.
O desafio maior que você
Well,
tem
the major challenge ahead of you is to acknowledge, to recognize the name of a person, a date or a card number. And there are several algorithms that allow you to do that, both as part of our tool or other random open source tools or closed source tools. But the major challenge is not only to recognize a person's name, but a person's name which is relevant to that company. And in order to do that, our approach is to follow that troubleshooting solution. I mean, always rely on our common sense. We start up by creating a dictionary of data which are relevant to a given company by taking the source of data which are part of the most risky processes. Data that are used as a routine in that company. So take the list of customers or clients and the list of employees. So when it comes to scan a Word file or a spreadsheet, if you recognize a name or address, you can make a reference. Or you can understand whether that name or that information is relevant or not. This is a good approach, and this order is very important to start with structured data sets and then go to unstructured data sets, whatever the tool use. And let me now talk about the SARs. Well, it depends on the company, whether you will really need to automate that or not. If it's a very, very small company, if you do not have too many customers, you can do that using your hand, by hand, or manually. You don't need to automate that. However, if the company's reputation can suffer a negative impact, or if you can get a fine, I mean, or if you have many people as customers, natural people as customers, and as Daniel said, if you do not automate, you need to hire people, many people to meet the requirements set by the regulation. And there is a cultural difference. I mean, if you compare Brazil to Europe, one of the risks you face if you do not automatize that, if you do not automate that, is that if you have a data theft, the last thing you want to do is to help the cause of the perpetrator, the criminal. So, for example, if you do not have a process in hand, depending on the requirement, if you do not have a process to anonymize that taxpayer number, probably, I mean, if you, I mean, you need, having this ability to mask data, especially personal data, is important, even to fight crime regarding identity theft and so on. If you validate the SARS, if you validate these requests, if you are a big company, you face the actual risk of facing mass lawsuits or mass requests related to data owners, to data subjects. So the trends in Brazil, I guess, regarding labor laws becoming harder and harder with a right-wing government, is that the trend is to focus on labor class actions, but now no longer labor class actions. We will now, I believe in the future, we'll have private or subject data mass actions or lawsuits. You need to be ready to face that. So this is it. These are my ideas.
Excelente, Leonardo. A gente já está encaminhando.
Excellent, Leonardo. Actually, we are pretty much close to the end, to wrapping up, but I'd like to read some questions, and you guys please feel free to answer them or even to make your final comments and suggestions, because we're here, we still have a few questions. I think 2 minutes each would be nice to wrap up, you know, giving your final observations. I can tell you this was such a rich debate, and it's so nice to see the multidisciplinarity thing about personal data. You know, there's the legal aspect, all the procedures about information governance, the technical and technological aspects, the usage of tools. I think the composition of this panel today was really nice. We could really learn from all of you, definitely. And I still have a few questions from the audience. Cleberton Soares, he mentions, hey, the laws, aren't they sufficient enough? I mean, why do we have a privacy law? What about good practices? Wouldn't they be enough? You know, the good company practices. I think this is interesting because he brings an interesting point. What are the good practices? What are the good corporate practices? Even if they're not mandatory, but do you guys share this vision? I mean, can we go beyond the compliance? I mean, I'm just provoking. I don't want to, I mean, we don't have time to actually develop this or elaborate this too much, but Puna, you spoke a little bit about the privacy shield, you know, about the international transference of data. I know, en passant, we don't have time to do this, but can you elaborate a little bit, you know, on this challenge that it has been for the companies, the privacy shield, and all the questionings about the contract, the standard clauses. How are the companies dealing with them? So then we can learn here in Brazil. I think this is such a great challenge that we need to be more integrated here, as in Brazil. We need to integrate in the global market. So what is the relationship that we have, you know, with the globe? And about the European Union, they say, oh, I'm a consultant, and it's hard for me to convince small and middle-sized companies. How did that happen in the European? Middle ones, they started already doing compliance. When did they start? Did they start? Didn't they start? What is your perspective in this aspect? So let's do this. Let's be fair. Viviane started So now Leonardo starts, and then Daniel and Punan and Viviane will be the last. So we have Leonardo. Actually, I'm going to comment with these small companies. I mean, the difficulty in the small companies. It's risky for the organization. You have small companies with many clients. In theory, you could ruin that company, that small company. Well, the ICO, at least here in England, which is Information Communication Office, it's a governmental body. What they have been doing is they don't tackle the first companies first. I mean, they try to, you know, guard, I mean, to save their data with respect, you know. But what happens with small entities, with some universities, for instance, really is negligence. I mean, people, sometimes they didn't even try to protect data. I mean, the most important thing here is data protection with small companies. Universities, they leave their data bank open, you know what I mean? So the focus of the government is either this company is being careless, or big companies that are careless enough that they don't have enough money to fight the legislation, you know what I mean? So yeah, the majority that what I see here, there's a giant difference. Again, I mentioned about culture and even interpretation of that, and especially about safety. I think that this really made a difference, but obviously the tools used are generally different from company to company, either small or middle or big. Excellent, Leonardo. Daniel, your considerations, your answers, your final thoughts, please.
I'd probably respond to two of the questions. I think to one of your questions around are laws necessary? Is the privacy law necessary? I think it's a great question around principal performance. I don't know whether people are aware of OJAC, which really is an open source, open standards organization based out of the US that talks about principal performance. So those firms that are looking to behave ethically with their clients' data and to really protect and hold themselves accountable for the responsibility to be the custodian of that data. We see those organizations and work with those organizations, and it's a real pleasure to work with them because they're driving it not from a, I need to tick the box, right, and I need to be compliant and make sure I don't get fined. What they're doing is they're taking their responsibility and their role in society very seriously. Those organizations are the best. That I love working with those organizations as clients on the GDPR challenge, because it's not just about getting compliant. It's actually about taking their responsibility for being a member of society to protect the data of those organizations, sorry, those individuals they work with. So I think that's a great point from your questioner. But also, I want to pick up on another point. The irony of being compliant with a regulation like GDPR and like LGPD is that in order to be compliant, you now need to know way more about your client, your customer, the natural person that you ever did before. You need to know where every atomic element of that individual, every item of data of that individual across your whole organization. Right? The discovery that's happened when working with clients about the data sets they never knew they had around those clients has been part of the learning that I've gone through. And I think those two are inexplicably linked. The principal performance of wanting to be able to take your role in response in society of protecting the data of the individuals you work with, but also having to know so much more about those individuals and so much more about the data you hold on those individuals is two things that work together to achieve great compliance. I'll hand back to you, Andre. I think they're the two things I can comment on.
Perfeito. Muito obrigado, Daniel.
Perfect. Thanks very much, Daniel. Punan, and your comments now? Your final comments, please.
Yeah, thanks, Andre. I think there were 3 points that you raised. One of them was from your question, which I agree was a very perceptive point that your questioner made about principles and whether it is actually necessary to have the legislation in place at all, given the fact that we should all be acting in a responsible and ethical manner. I think that's very perceptive, because that is actually all about the GDPR, right? I mean, the GDPR sets out 7 principles. It's not particularly prescriptive at all. It simply says that how you process data needs to be lawful, fair, and transparent. It says that your purpose needs to be limited to the original reason you collected it. Data minimization, accuracy, making sure you process the information with integrity, security, and confidentiality. These are all very principle and ethical based. So I think it's very perceptive that that is actually a comment from your questioner. And I think in terms of the second point, which was probably aimed at me in terms of how the Privacy Shield decision from the recent case that was brought by Max Schrems has changed the landscape. This, I think, is going to change things very dramatically for those who process information backwards and forwards between the EU, UK, and the US. The US is a major partner for us here in the UK, and especially will be once Brexit happens. So this case has come at quite a key and challenging moment for us. And I think data protection specialists all over the land are looking forward with quite bated breath for the equivalent of the Privacy Shield, which is, there's a possibility will be coming through that will be designed to work and operate between the UK and the US only, so that therefore there will be a structure that will take place between how we, regarding how we transfer information from the UK to the US, and that will be set out by legislators specifically. So we'll have our own Privacy Shield that's focused on that. And then I think in terms of the comment that was made about small companies, I don't think of data protection as being focused on big companies or small companies. I don't see it that way. What I think of it, in the sort of terms I think of it, are what is the personal data? What are the special categories of personal data? You could have a one-man band that's processing large-scale quantities of personal or special category personal data, and they would need to have rigorous controls in place. On the other hand, you could have a large corporate that isn't processing any personal data, and you could be less concerned. So for me, it shouldn't be how big or small is the organization that you're looking at. You should be thinking about the personal data itself. And by thinking about the personal data itself, you're thinking about the data subjects. And that is how GDPR has now been drafted, with the data subjects in mind.
Perfeito. Muito obrigado, Punan.
Perfect. Thank you,
Thanks, Punan.
Now, let me call Viviane to close our panel, and after Viviane, Rodolfo, ABES chairman, will wrap up this webinar. Viviane, back to you. Well, I have the mission of being the final person to speak here before Rodolfo. So let me take this opportunity to once again congratulate ABES for allowing us to share our experience. Is always a rich experience, especially for Brazilians. We still lack information. So any opportunity to add experiences and share examples should be broadly valued and cherished by us all. Let me also talk about the law enforcement. I believe this perspective potentially varies from culture to culture. I particularly, I mean, regarding that question about LGPD, whether potentially we could do away with this law and rely on other mechanisms or rely on other regulations to reach the same goal or the same purpose. Well, the fact is that we have had some legal frameworks in different areas already, specifically dealing with data protection. But I personally think that the existence of this movement in Brazil is highly relevant in order to pass a law, because this does not deal only with behavioral, the behavioral aspects of companies, but I think that for the whole country, it's important, it's so relevant to have this reputation as a nation regarding, I mean, being seen as as a country that complies with privacy laws. And this also reflects in business deals. And there is the rationale of international transfers, international data coming from Europe, and that is the obvious need. Also, there is the matter of OCD, and Brazilian company owners are submitted to GDPR in some specific circumstances. So Brazilian business owner must already comply with the European regulation if they provide services or products to European consumers. So even digital services, they need to rely with that, even if they are not based in Europe, even if they they are not Europeans, if they sell products or service to European customers, they must comply with that. So there is this, the country wants to make viable a certain flow and better positioning of the country before the international community, especially regarding this reputation aspect. Besides, there is also a cultural aspect. I like to provide people with an example, which is, I mean, many years ago, you could drive your car without the safety belt, without wearing that. And back then, we would the turn on the car, and then you would manage the gears of your vehicle, and you'd start driving, and you thought, well, no one will find me, no officer will find me. However, today, if anybody tells you not to wear a safety belt while driving in a highway or even on the streets, you will not accept that, because it's your own safety which is at stake. But in order to reach this point of maturity, you needed to pass through a phase of enforcement. Remember, back in the day, we could smoke inside airplanes. Picture someone smoking a cigarette within a plane today, nowadays. So society needs to grow aware through enforcement. It's part of the game. Human beings oftentimes need rules, guidelines, limits, and borders for their own good, for their own progress and evolution. Well, somebody talked about sharing our contacts. I'm very active at LinkedIn. I publish articles at LinkedIn almost every day. I share my opinions. I have several content there at LinkedIn, so please feel free to talk to me and add me there. Just use my full name, Viviane Nóbrega Maldonado. It will be a pleasure to keep talking to you using our social media. Thank you very much. Well, once again, thank you all very much, Viviane, Punan, Daniel, Leonardo. Thank you for accepting this invitation to be with us in the international webinar. I believe it's late where you are now, right? So thank you once again. It was a pleasure to have you here, to count on your lessons and to enrich our debate, to count on the lessons provided to us from the old continent. So let's learn from the lessons of those who have done this for a while now. Thank you very much. Now, our chairman, Mr. Rodolfo, will close this webinar. Thank you very much to all of you. Let me repeat what Viviane said. Let me rephrase what she said about culture. I fully agree with her. We need to consider the adequate treatment of personal information. This also has to do with our reputation. We will improve our reputation as company if you do that. This is already on. This is already going on. If somebody asks you information, I question this person. If somebody asks me, oh, my taxpayer number or my identity card number, then I ask this person, why do you need this information? Why are you going to use this information for? And oftentimes people just tell me, no, 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 I don't need that. I don't really need your numbers. So we need to be more aware of that. Let me thank Punan, Daniel, Andriei, Leonardo, and Viviane for their comments, for their participation. Thank you very much. We are about to finish, to wrap up. Thank you once again, and let's continue in this learning process. Thank you.